medical issues, and as a result of that, either is it COVID specific or is it another disability and there's no care available for her child as a result of that. I've seen both of those. And I guess the other question is the employee covered by a collective bargaining agreement? And if so, is there sick pay?
So big lesson learned on Zoom meetings. Make sure they just go out to the membership and they don't go on the website. So sorry, guys. That was on me. We won't do that again. We're glad you're all joining us again and making it back in.
We're going to wait a few minutes. Lucy and I are trying to admit everybody here as the new link went out. So bear with us a minute as we're both trying to admit here. So as Lucy said, no good deed goes unpunished. We're trying to make sure that it got on the website so that if people didn't get an email or their new business managers that they had an availability to the link, which obviously you can see went south quickly.
Thanks, Teresa. I'll talk to that in just a second once we have everybody on. So.
Well, thank you all. Sorry for the inconvenience. For those of you who just got on, we did post the link on our website, which is obviously where they got it from, and we for new business managers as well as folks who may have not been on the email list for some reason. So lesson learned on that one. We certainly won't be doing that again. The other thing I'd ask, that shouldn't be an issue moving forward. If you have a very generic name in your Zoom name, when you join the meeting, the next meeting, just add a little bit more, even if you don't want your full name. So will help us identify and make sure that one of us who are admitting at least know who you are. So Mike, welcome back.
Yes.
I know, let's start with Teresa's question. I'm assuming everyone can see the chat box as well, but if you can repeat it, Mike, just in case.
Absolutely. And actually, this is one of the questions that sort of gets right into the intersection between the baskets that we're used to and the new paid leave provision. So the question is, there's an employee who's home because her child has medical issues. In this case, it sounds like she has a heart issue and is scheduled for surgery in October. And so she can't work at home, presumably because whatever the position is, it needs to be in person, or we're not able to create some remote position. And we don't have anything with her job that she can do at home. So same sort of thing, which is coming up. So does she qualify for any other leave besides the 80 hours at 2/3 pay? So the 80 hours at 2/3 pay, for those of you who aren't necessarily right up in front on this, is under the FFCRA, and that would be for somebody who's caring for an individual subject to an isolation order, or for an individual who can't come to school. In this case, it's interesting. It's either or, but the caring for an individual subject to an isolation order certainly would apply. But in this case, I also think because of the medical condition, this is one of those rare circumstances where even though we are offering school, because of that medical condition, as a result of COVID-19, school is actually closed to this child, right? And that's a pretty rare circumstance. There was actually guidance that was issued yesterday from the DOL talking about this specific issue. And unfortunately, it's a little sloppy because they're moving fast. In that guidance, the question there was whether, if a school is providing both an in-person and a remote option, and the parents choose the remote option, right? Not for a medical reason, but simply because they're worried or they don't want someone to bring COVID home to the family. In that case, the child care leave would not be available according to that guidance. But in this case, because of the medical condition, again, I would take the position that school is in fact closed to this child, right? But in addition, you also have the isolation order, right? So those two things are going to overlap. And then this employee is subject to the collective bargaining agreement. It looks like this employee is going to get 10 new sick days. So presumably this is somebody who supports staff. And they will be able to use those. In that case, you're moving into your same buckets, right? So take, for example, someone who has, let's just put it in this light. You have someone who needs to be home to care for their child who is subject to the isolation order, right? And in that case, they would otherwise qualify for their normal FMLA provisions, right? Remember that FMLA in that circumstance, if you are home caring for someone who has a medical issue, you're entitled to whatever FMLA would provide to you in addition to whatever you usually have, right? That you can use those sick days, and then at some point that leave would be unpaid. I think this is actually, I mean, you've essentially asked the most interesting possible question, because at the end of the day, it's completely gray, right? But what you know is that this doctor has said this child needs to be home. And what that means is essentially school is closed, right, to that child, even if we are open. And we've talked back and forth internally on this. Again, every one of these questions is incredibly tough to sort of suss out. But in this case, depending on the documentation that you have from the doctor, I think that you could certainly make the argument that this would essentially close school to that child at this moment, right?
So I think a kind of an offshoot of that, not with the medical side, Mike, is, and I think a lot of us are facing this, especially with the hybrid schedule. Can you just address for a second in your example, students going Monday and Thursday, they're not going Tuesday, Wednesday, and Friday. Does that qualify as school is closed?
Right. So that same FAQ that came out yesterday attempted to address this issue. I've been talking with people about it, honestly, since the spring. The interesting thing about the FFCRA is it specifically says that the leave for childcare for school closing is not required to be given on an intermittent basis, right? So for those of you that sort of work in and around the FMLA world, there is intermittent leave that's available to people. And the legislature initially said intermittent leave is not a requirement for this childcare leave, right? Presumably the idea being that if school was going to be closed, it was going to be closed for a period of time. Remember, this law was passed in March before we all started trying to figure out how to get kids back to school. The guidance yesterday said that to the extent that there is a hybrid schedule, right, that the parent would potentially qualify for that leave on those no school days for the child. The frustrating part is it's sloppy, and it doesn't address the language of the statute that initially says you don't have to give intermittent leave. So it's still an open legal question, but I just want to speak to it from the reality side, right? And that's what we've been dealing with since spring. The reality is that we've been trying to figure out ways to have people work remotely when necessary. We've been flexible around that. And ultimately, if we can be flexible, I'm finding that most districts are choosing to be flexible, right? So even though they may not need to by law offer that intermittent schedule, ultimately it seems to be the best option for people. So it's still an open question whether, the FAQ I don't think necessarily replaces what the statute says, but from a practical perspective, if we can, I'm finding that districts are trying to work within that parameter, right? And now the thing that I will sort of leave out there though, ultimately, if someone truly is just not able to work because of whatever their childcare situation is, specifically with younger children or things like that, they may just need to take the actual full 12 weeks of leave, right? I mean, that's an individual decision, in which they certainly can do. But I have found that for the most part, districts have been successful in sort of talking with people about what they really need, what are they able to do? Is there some sort of flexible work arrangement that we can figure out for the time being?
And that kind of goes into the next question from Barbara, which is anyone planning flexible work arrangements for staff working due to their own child's school or childcare situation? Which is kind of what we're just talking about, right, Mike?
Yeah, and I've heard of a couple different arrangements. The issue becomes whether so there are different versions of hybrid schedules that are going around right now, and it sort of will depend on what your district is doing if you're in that hybrid model. There are some districts that are essentially having simultaneous learning. So one cohort is in the classroom while another cohort is essentially remote while learning, right? And so in that case, that teacher is in the classroom the whole time. It's just kids are shifting in and out. So that's a more difficult situation, as opposed to someone who is doing part-time in the classroom, part-time out. So some districts are trying to align the teacher schedule with the student schedule. It's a very individual decision. And then for those folks who continue to have the childcare needs, some districts have been successful shifting those folks into the remote teaching positions that they have. Essentially, those folks have elected into them. And we have been able to essentially line up the people who need that with the other folks. But in a support staff situation, it's a little more difficult because honestly, the whole idea of support staff is that they're actually supporting. So you're going to have to look at that on an individual basis and see ultimately what works for you, with the caveat that at the end of the day, it's still in everybody's best interest to have as many people as possible come back, right?
Thanks.
Can I answer that? Colin?
Yes, Barbara.
I think I'm concerned with trying to make arrangements to accommodate teachers. We're doing a hybrid model Teachers are expected to teach 4 days a week. Students are coming in 2 days in one group, 2 days in the other. But if you start to make a flexible arrangement for a few teachers, you cannot discriminate. So I feel that that request is going to grow. And you made a good point earlier that the reality is we can't have all our students in school or half the students in school if 35% of our staff is not coming in to do this. How do you bridge that, or what are other schools doing?
So the answer is you punt, but the practical reality is schools have been having conversations with people, very frank conversations about what they are able to do, and trying to figure out if there are other options. And ultimately, I don't have the answer because it's really going to depend on the number. So I have some districts right now where nobody wants to be remote. They're probably tired of their children, but the reality is that it's much easier for them. In the districts where we have more people asking to be remote than we have remote positions, that's a really tough question, right? And what we are doing is starting first with the essentially those folks who have requested remote work because of a disability, sort of essentially under the ADA framework, right? Because we have a legal obligation to work with those folks and try and figure out what, if anything, we can do to accommodate their ability to continue to do the essential functions of their job. And then dealing with the childcare piece, that's why I was saying early on, I like to separate these things as opposed to flexible work arrangement request and accommodation request, right? It's not perfect. And in every situation, if you end up with all of these teachers who are in a pickle, I don't have the answer. And for the first time in my illustrious legal career, I often say, I don't know. So at this point, I still try and talk with those people. We can push back a tiny bit to say, are you really unable to work, or what's your situation? But at the end of the day, if they say they can't, they would be entitled to leave. And if that's their only option, we'll have to explore that. So.
Thanks, Barbara. Kate's question is, I have a similar issue. The employee is choosing not to send her child to school because he's at risk of a serious complication if COVID is contracted.
And so in that case, I would ask for some version of documentation, right? Because if you think about what the new laws contemplate, it's ultimately that somebody is required to quarantine or isolate, or is under that sort of suggestion from a physician. So it's not that they can't get it, but if someone's just saying to you, I'm concerned that my child might have this, I do think you could ask for something more. You still need to engage in that process with them. But what I'm starting to get, and honestly, they'll be able to get it, is physicians have figured this out. And so most of the notes that I'm seeing now are somebody is required to self-quarantine because if they were to otherwise contract COVID due to their underlying condition, there is an increased risk of complications. And if you have that, then we will need to sort it out sort of the way that we've been discussing.
Is there a list of what is considered essential employees?
So under the governor's order, all school employees are essential employees. That hasn't changed. But from a more practical perspective, honestly, it would still be all school employees, I think. Is there a specific circumstance that you're thinking about?
Who sent that in? K-Flag? Can you unmute and give more info on that?
Yes, it was mentioned the other day about who is considered an essential employee and who is not, and I didn't know if anyone had any more information on that.
So yeah, that does go back to the original governor's order that all school employees are considered essential employees. I know that the associations have sometimes pushed back on whether what we're asking somebody to do is quote unquote essential. That has sort of fallen away now. So at the end of the day, under that governor's order, all school employees are still considered quote unquote essential employees.
Thank you.
Just as a side note, Lucy and I have excluded a couple of people from admins. Again, if in future meetings, if you can give as much of your name as you can. There's a couple just generic names of iPhone or something that's very generic that doesn't really help us in trying to vet who enters. So if you could share that with people that you're close to who are other business managers, it'd be appreciated. We want to include everybody. But obviously, as you saw earlier, we got to be a little more careful and not post it to the website, and also be careful what people's names are. So if you could share that around, that'd be appreciated. I don't want to exclude people. I really don't. But we also have to do vetting. You want to talk a little bit, Mike, about MOUs, because you mentioned union. I know the unions are pushing the pretty strong right now.
Sure.
Use and just, I don't know how much business managers are involved in that. I'm not sure we need every detail, but just how does that affect us as business managers, and what do we need to watch out for? Business managers are communicating with their superintendents on this.
Absolutely. So there has been a trend. It started with the National Education Association and is now moving through the MEA. There was initially a sort of draft MOU that was sent out to most units. It had 120 paragraphs of all sorts of things. Some of them potentially negotiable. A lot of them were educational policy. Some of the more concerning ones had to do with attempts to find increased compensation for doing work for salaried employees, things like that. And so depending on where you are and ultimately who the UNISTER director is in your area, we've seen some different versions of it. And I've worked with a number of districts. We're all sort of working in and around it. And what I've found to be a pretty successful starting approach is to meet with the association, because under the reopening plans and the teams that we've been required to put together by DOE, the association is already heavily involved in sort of coming up with the reopening plans and all of these different things. And so I think it's really important for us to hear them, to listen to them, and to figure out what the actual concerns are outside of the stuff that we're already doing. And in that, the concerns really seem to be, and this will apply directly to you guys, I think the biggest ask so far is for not having to use their own sick time, right? And that is something that is already in our contracts, right? So for those of you who do have contracts with zipper clauses, and what a zipper clause is it essentially says parties agree that we're not going to reopen this contract during the terms of the contract. We've negotiated what we need to for now. But every contract defines when and how you can use sick time, right? Some are broader than others, but that's going to be your starting place. And the reason why employees are asking for that, and I understand, I am not the person who is upset when employees ask for things. I get it. We've been in this space now for 6 to 8 months where everything is telling people that they need to be really afraid, and so they are. So what they're asking for makes perfect sense. The question is just whether or not we've already negotiated it, whether or not we're already doing it under these very extensive reopening plans that you guys have all been involved in, or if it's something unique. And so in the case of the sick the use of sick time, right? That one is harder, I think, because you do have this definition of when and how you can use sick time, right? And we do have federal laws now that give people a certain amount of time. So I think it's really important to hear the association out. And ultimately, if they do want to bargain over working conditions under Maine law, they can. So I have a couple of districts that are engaging in those negotiations, but that's not any different than what we would need to do as part of our negotiating process. The difference is they're asking to do it quickly, and the reality is that we are focused on opening school, right? So the other piece that's coming up, there's a lot of stuff around sort of the health and safety guidance that's coming from DOE and CDC, and schools I think have been pretty successful talking with the association and saying, is there anything that you perceive that we're not doing because you're part of this process and we're doing all these things? And now yesterday we have the governor's executive order that says in order to receive state funding and subsidies, right, we're agreeing to follow these guidelines as part of our reopening plans, right? So I think all of that has sort of quelled some of these things. But the thing to be cautious about is, as you have all seen, the guidance changes every day, right? I'm telling you things today that I didn't know yesterday. And in order to have a working document, I just don't see how districts can agree to sort of specific procedures in an MOU that may be pulled out from under them or changed completely within the next 2 weeks. Perfect example is sort of the changing guidance around use of PPEs and masks, right? I don't know if you've all seen, but the DOE has just recently put out additional guidance. They actually had a pretty helpful, what amounted to a chart of what kinds of PPE are required for different employees, right? So it is a moving target. And one thing that I might suggest that has had some good success in some districts is instead of ultimately signing an MOU, agreeing to make what amounts to a public statement with the association about our commitment to working together and to figuring these things out. Because at the end of the day, we're all in this together. We're all trying to figure it out together. And we need everybody's buy-in to do that, community members included, right? And so there has been some success and support for that, which I perceive the community has appreciated as well.
Thanks, Mike. If there's follow-up to any of the topics we've talked about so far, go ahead and use the raise your hand feature and we'll circle back so you can elaborate and unmute on that. Kate's question is, if we are in person for all staff, which means hybrid for students, and have a note that an employee's doctor that due to their anxiety disorder needs a reasonable accommodation to work remotely, can we offer FMLA? Or do we need to accommodate for remote work for this teacher? Hiring a 40% teacher will be a challenge is her comment.
Yeah, so this is one of those ones where ultimately you guys know how to do this version, right? So you have a request for somebody. Remember first and foremost that doctors don't tell us what accommodations we have to offer. Right? The role of the medical professional is to tell us in the ADA context what the disability is and what the restrictions are. And then it's up to us to engage in the interactive process with the employee to determine what would be a reasonable accommodation. And remember, it's what reasonable accommodation will allow the employee to continue to do the essential functions of their job. And in this case, you've got somebody who has an anxiety disorder, right? So that would certainly qualify. And the request, the doctor says, well, I think if they were able to work remotely, it would help, right? But what we are saying, and what we'd be saying to the employee is, okay, tell us more. We want to know what the actual restriction is, right? And what is it that you're not able to do? Because there may be some more limited accommodation that we can offer that will actually allow the employee to do the work. But ultimately, if what the employee is saying is, I just can't be in school right now, and that's not something, let's say, for example, I actually dealt with this yesterday, a PE teacher who had issues about being in school. And in this district, they are returning to school full-time, and having a remote PE teacher, just, it doesn't exist, right? They're not offering that. So in that case, the choice that the employee had to make was, if they weren't able or feeling like they couldn't figure something out with us, then FMLA really was at least their initial option, right? And remember, we know how that works. With FMLA, you have an employee who says, because of my own serious health condition, I can't come to work right now, right? And this, I think, would qualify. Anxiety is certainly a serious health condition. And in that case, they would move through that FMLA time, assuming that they have it. Remember, there is a barrier to entry. So if they qualify for FMLA, that's fine. That FMLA, otherwise, depending on the circumstances, in this case, I guess it would depend on the doctor's note that you get. I suppose you can get a doctor's note that says, because of this, they're required to self-isolate. That seems unlikely. But otherwise, you would just move them through that process. What would happen, though, is that at the end of that 12 weeks, right, then you go right back into the ADA process. And at that point, you're asking the medical provider for an update, additional information. And the most important question is, what's the prognosis, and when, if ever, will this employee be able to do the job? And you may get a note that says, when COVID is over, right? I don't know what to do with that. But that, to me, sounds like we're getting closer and closer to potentially, indefinite leave. I've not had that question yet, and I'm not saying that I know the answer at that point, but I think that down the road here, depending on what happens, we may see more of that.
Yeah, the kind of follow-up to that, Mike, is, and I know we're not alone in getting these notes, doctors seem to be writing some very generic notes right now, at least in our experience, which says,
yeah,
due to this person's medical condition, we strongly recommend that the employee work remotely.
Yep.
Is that another situation where we as business office professionals have to dig deeper into what that means, either with the doctor and or with the employee?
Yep. And so remember that we've got, again, two different tracks, right? And they never come cleanly to us. If we have a request from an employee simply to be out of work because of their own serious medical condition, right, we're going to send them the FMLA paperwork, assuming that they qualify for FMLA. We're going to get information back. It's really important, and like you guys don't have 1,000 other things to do, but when you get that FMLA paperwork back, it's really important to go through it very carefully to make sure you have actually received the information you're entitled to. Oftentimes we get these very incomplete forms. And if that's the case, you can send it back to the employee and say, I need you to provide me with the information that's on the form. Under the FMLA, we're limited to the questions that we can ask, but we can still make sure that we are getting all the information on that form. In particular, how long is this expected to go on for? There are all these different boxes that we can ask for. So it is absolutely okay to say to the employee, I need you to take this back to your doctor and get me the actual information. If you're getting a more generic request, right, we can also say, thanks, I'm happy to engage in this process with you, but I'm going to need more information from your medical provider. And I would really encourage you to get that information from the medical provider, because in the springtime, everybody was really loose, right? Because we had no idea what was going on in terms of how long things were going to last. At this point now, I really encourage you all to be tracking actual FMLA time, which I know most of us didn't do in the spring, right? And to get back into that habit of moving through our baskets, right? Because we're going to end up in a place perhaps 12 weeks from now, where FMLA has expired for many people, and we're going to need to make tougher decisions at that point. And we need the documentation in order to help us in figuring out what accommodations, if any, we can offer. So that's my 2 cents on going forward, adding yet another thing to your to-do list, and I apologize. So.
Katie's question is, if we have staff that can't come back due to from vacation and need to get tested, do they get covered by sick time or FMLA during their wait time before the test comes back?
Right.
And we add to the other side of that, and it seems insignificant, but it's come up in our district, is the district going to pay for that test?
Yep. So all of those are in the land of, on any given day, the answer may be different, right? So, but just to understand the framework, right? The reason this comes up is, one, because we have the FFCRA that says if somebody is required to quarantine, right, we have to give them 2 weeks of pay. Then we have the governor's order, the executive order that has changed over time, that essentially says if people, and this is interesting, right? But what it said was if people were traveling to the state of Maine and they wanted to stay at the Hampton Inn, the way that they could stay at the Hampton Inn faster was to get this test, right? And then we have essentially tried to overlay that onto the employment context. And I know I have districts that are saying to people, if you are traveling to a state that is otherwise not on the approved list for a non-essential reason. Remember that there's still this carve out for essential reasons, right? For a non-essential reason, then we expect you to comply with the governor's orders. Now, what does that look like in practice, right? What I have are districts who have already or are in the process of notifying employees essentially that they expect them to be available for work, right? So at the start of school, it is our expectation that you will be here. And if you're not available for work because of a choice that you make that subjects you to either potential quarantine or other things, then essentially that's on you. Now, here's the thing. Like I said, it's gray. I don't have an answer. I have some districts that are saying to folks, if you provide us with the negative test, you can come back. I have some districts that are also essentially saying if you're required to quarantine because you chose to go on vacation, we're not sure whether we're going to pay you, right? I think it's important to start with the initial framework, though, which is under the plain language of that statute, they might still be entitled to that leave. But what I'm finding is on sort of the practical response is most employees are being very responsive, right? The reality is that, and I saw yesterday, IDEX now has a new mobile testing site. Most folks are able to very quickly get a test, right? Colin, to your question of whether we have to pay for it, the employee-friendly response would be yes, right? Because we're requiring it. That hasn't been tested, and I have no idea if it gets litigated 3 years from now or arbitrated what the result would be, right? Same way with if you have an employee who agrees that they're going to get a test, and for whatever reason that test takes X number of days to come back, do we need to pay them while they're out? Again, I also don't have the answer. What some districts have been doing is allowing employees to use their personal time, right? That's not sick time, it's personal time, so it can be used for that. And this is all in the circumstance, understand, of somebody who is essentially chosen to go away for vacation, knowing that in going away for vacation, they're going to come back and not be able to work, right? That's the bucket that I'm talking about. And so I don't have a satisfactory direct answer, but I do think that we need to make employees aware, if you haven't already, that they are expected to be available for work. And if they make a choice that makes them unavailable for work, we may need to consider that on an individual basis, right? And I am aware that there have been documents that have gone around, sort of language that you can use. I have worked with districts on that, and it's going to be a district by district decision. The association in some districts has gotten sort of very upset about that, and in other districts it's been fine. It's going to depend again on where you're at. So.
Next question is employees, again, who travel out of state for vacation that are not exempt when returning to Maine. Do they have a paid choice? Can they quarantine or get a test to return to work and they want to be paid for those quarantine days instead of getting tested? Or can we make those days unpaid?
And so, yes, probably up to the district and individual cases, that is correct. The most important thing, though, is we still need to notify employees of what our sort of expectations are, right? I think it's hard at this point for anybody to say that they didn't know, right? But I still had somebody the other day say, I had no idea, right? So that's part of why with these sort of reopening guidelines that are going out from schools, we're making it clear that it's our expectation that employees are going to be safe, that they're going to respect the health and safety of the community members, and they're otherwise going to be available to work, right?
I think at this point in the chat box, we're caught up with questions. If there's someone who submitted a question and we didn't answer it fully or to your satisfaction, just let us know. Do other folks have questions? I know we've covered some territory. Are there topics, even if it's not a specific question, but a general topic that you would like either to hear from your peers or to hear from Mike on? Kate wrote, Mike, that they technically could fall under the 2 weeks, 80 hours of emergency leave to quarantine. Is that correct?
Yeah, that is correct. And what we struggle with is ultimately whether that was the intention of this statute, right? And I have my own personal opinions about that. But the reality is we won't know until 3 years from now, when after somebody files a lawsuit and works through that process, right? So from a plain language of the statute perspective, I think arguably this would be covered, right? But it's very strange to begin with because the only reason they'd be required to quarantine is because of an executive order, not because they're otherwise showing symptoms or having a medical condition or other things like that. So again, it becomes a sort of district decision about what line you'd like to draw. And I don't have the answer to that, but like I said, you are correct from a technical perspective. They could potentially qualify.
I think you and I talked on the phone the other day, Mike, in preparing for this. The other side of this is that with any new law, there's always that period of unclear language interpretation, and then a period of time after a law is put in as to how it's going to be either interpreted or gone through the courts, if it even makes it that far.
Right. And to this question about are people requiring quarantine testing for overnight travel only? It's an interesting question because if we don't know, right, then how would we require it? I feel like we are in a tough spot because each case is different, right? The one that I think comes up frequently right now is people who are taking their kids back to school, right? And so you have kids who are going back to college and you're driving your kids back to school. And so if somebody drives their kid back to school, doesn't do anything except drive, drop them off and come back. First of all, I might be able to find my way into saying that that's actually essential. I haven't pushed too hard on it, but I'm a parent and for me, that would feel essential, right? And so I think it really comes back to we're trying to engender trust and we're trying to do the best that we can. So I think being reasonable is okay. And at the end of the day, I'm not sure what every district is doing. I'm not sure if people are saying, hey, so for example, let's be slightly absurd, but if you're in the car and you intend to go to Hampton Beach in New Hampshire and you accidentally drive across because you, like me, were not paying attention to where you were supposed to get off, and so you drive into Massachusetts, you go past that stupid rest area that's there that the bathrooms are never open, and you turn around and come back, right? I don't think you're required to quarantine. I don't think that's what the intent is, right? But again, I'm Michael Busher, and I'm the one that missed the exit. So I think it really is a case-by-case basis. I do think that there's a difference between going on vacation, right? Living somewhere, being in and around the community, and otherwise sort of the in and out, right? We've had some people self-report, ask about things like going to Massachusetts for their child's baseball tournament. Again, same sort of thing. I think that gets more to whether or not you're going to ask them to have a test before they come back. Given the availability of those tests, I'm finding more and more that seems like a reasonable ask. But again, it's a case-by-case basis. And everyone is ultimately trying to keep everybody as healthy and safe as possible. And I understand that sometimes imposes limitations on sort of what we do in our personal lives, which is frustrating. So.
Lucy's question, I'll read it so that if you aren't reading along, how many times can the 2 weeks of FFCRA emergency leave be used?
Just one.
Lucy's in East Millinocket. We had an outbreak and are completing our 2-week quarantine.
Mm-hmm.
When school starts again, if we have to shut down and quarantine again, do we get another round or not?
No. So the FFCRA, it's up to 80 weeks. That's it. That's set to expire right now in December, but there isn't a new round of paid leave. Then we would just be into the FMLA process and so forth and so on. So.
Other questions or topics from you folks, or stuff that you'd like to hear from your peers on how they're handling, or how we as business managers are dealing with some of the logistical things? While we're waiting for that, I do want to say that if you could email topics that you would like to see at future Zoom meetings, please email those to the MeASBO. Please don't email me or Lucy directly, because at this point, she and I are both trying to go through inboxes just like you folks are that are full, and I don't want to miss it. So please send it through the website email. We do want to hear from you. We do want to hear what topics are important to you. And then we also want to hear, was today worthwhile, and is this forum worthwhile to you? If yes, we want to hear that. If no, I want to hear that as well, but I'd like to hear, if it's a no, what forum would you like to try that might be different than this one, if this didn't work for you. The goal for us as an executive committee was engagement. It wasn't for us as an executive committee to sit back and say, here are the topics. It was really to say, okay, what do we as a collective really want to be talking about, learning about, and hearing, either from professionals and or from each other. And I think during this time, that's pretty important. I think that's a pretty important sharing and collaboration amongst us all. We may all do it in smaller groups, but I think it's also important to see and hear what we're all doing and what our struggles are. We all have them. And what are those that are at the top of your list that we might be able to provide information, guidance, or just a sounding board in order to help address. So that's our goal in the next short term. The short term may be between now and December 31st. in the fall and early winter. It could be the rest of the school year. None of us really know what's happening or how it's going to happen, but so that's kind of where we're at. We really want to hear your topics, though. We'll pick some if we don't hear from folks, but I'd like to make sure that we have that. Lucy, for FMLA, due to the 10 weeks available for childcare school closure, do we consider that FMLA ended at the end of June, even if only 8 weeks were taken or intermittent? If still needed, do we consider a second request for a second FMLA that would qualify?
It's a good question. So whether an employee qualifies for FMLA is going to be based on how your policy applies FMLA. For a lot of schools, that means that it tracks the new school year. So given that most schools did not otherwise track FMLA for the first part of this, my assumption is that most teachers in particular are going to qualify for another 12 weeks of FMLA. But it's going to depend on what your FMLA calendar is. And then the other one that comes up is if somebody was out for non-COVID reasons while on FMLA, whether pregnancy or other things that come up, right? And whether they would qualify. Again, you're going to go through your analysis based on when your FMLA calendar starts. And so I suspect that for teachers in particular, most of them are going to qualify for a new 12 weeks of FMLA. With support staff, it would be important to check what their actual hours were, because remember that under the FMLA, you need to have worked 1,250 hours in the year prior. So that for us is our usual analysis of whether you would qualify, whether or not it was for the childcare leave. And again, it's for the childcare part, that is simply a new category of FMLA, and you would treat it the same way that you would analyze whether anyone else qualifies.
Next question is, do you have to send the letter each year for proration? Employees, hourly employees, part-time employees, if they were spread out over the year?
So that goes back to the changed legislation, and remember that employees now are absolutely entitled to do that. So you're also going to want to look at what the terms of your collective bargaining agreement say, because oftentimes the collective bargaining agreement has a provision in there that says employees are going to notify us at the beginning of the year, right?
Under FFCRA, school day closure leave states first 2 weeks are unpaid and the remainder of leave is paid at 2/3.
Mm-hmm.
Employees are asking if they can use their sick or general leave during the 2-week period.
So
Unpaid.
interesting question. It's under the FMLA piece, right? So it's actually that the first 2 weeks are paid pursuant to the Emergency Paid Sick Leave Act, right? And then the remaining 10 weeks under FMLA. So those two things are going to work together. It's a little confusing sometimes. But ultimately, the sick leave question has to do with what is defined as a permissible use of sick time under your collective bargaining agreement. And most of those collective bargaining agreements, I don't think this would qualify unless you were home caring for a child who had a health condition. But again, that's going to be an individual CBA question. And that is one of the things that's coming up, whether or not ultimately, and it's an individual decision, whether the district wants to talk with the association about allowing people to essentially net up using sick time the same way that we do with workers' comp. But remember, the workers' comp, that is subject to the collective bargaining agreement, right? We have provisions in the collective bargaining agreement about allowing people to do that. So if you're considering it, ultimately, I would suggest that you talk internally and figure out whether it's something you want to do. And if so, because it's covered by the collective bargaining agreement, you may need to engage with the association on that. So.
Back to the one about proration, the follow-up to that, Mike, was it's in our collective bargaining agreement. So does that mean we don't have to send a letter every year?
So it's in the collective bargaining agreement that they can elect it. I think the ultimate issue for me is that it's still the choice, right? So the law said that now we have to give them the choice. So remember, it used to be that we would bargain over whether or not we wanted to, because for a lot of you, trying to prorate, especially for hourly employees, is a huge headache, right? So we actually pushed back for a long time. And then the MEA was successful in getting the legislation passed that says we have to offer that. So really, it's, I think for you from a sort of records perspective, I would just want to have the employee confirming whatever it is they're doing. But if the collective bargaining agreement says this is what we're doing, right? And there are a couple of those that are out there. So I realize maybe you have one of those that says all employees will be paid prorated. Then I'm not as concerned about the election. So.
I've had people ask about signing waivers. Is it possible to have students, staff, and families sign a waiver acknowledging the inherent risk of contracting COVID before returning to school?
So this is one of those thorny issues. I am aware that the DOE had sent out to folks a potential sort of acknowledgement form, and immediately what happened is some districts asked people to sign it. They said no, right? So at this point, I don't advise doing that, mostly because I think it creates confusion, right? Instead, I prefer to, like we were talking about, state our expectations. We expect that people are going to follow the CDC guidelines and that they're going to do the things that we need them to do in order to keep our communities safe. And if you are a district that has sent out some of those waivers, that's fine. But I still think you need to make that notice, because people may be under the unintended impression that if they don't sign it, they don't have to do it, right? So it's a local decision. I'm aware that some school boards have asked folks to sign waivers. And again, at the end of the day, I think it can sometimes create confusion and more fear, which is my hesitation. But it is a local decision. And like I said, I know the DOE sent out that form. And at the end of the day, my concern really is just that I sometimes feel like if you ask somebody to sign something and they say no, their impression is they don't have to do it. And that's not the case here, right?
For expanded FML, it's about the 30 days of being employed. Do they also have to work at least 1,250 hours?
So I confess right now that I believe they still need to. So remember, the 30 days originally under the FML and the non-expanded FMLA, you had to have worked for 12 months and also worked 1,250 hours in the preceding 12, right? And so that piece, I confess that I don't know off the top of my head, so I can get back to you guys with the answer to that. I haven't had it come up yet, because for most folks, they have already been employed. But I can certainly shoot Colin an email with the actual answer to that. I just don't want to mislead anybody. So.
Our FMLA year runs July to August. Just for clarification, if someone uses 12 weeks of FFCRA, then they would not qualify for FMLA again until July 1st. Is that correct? If you're employed for 30 days, again, you would have to work over 40 hours to reach the 1,250.
So the first part of that question is yes. If you've got somebody, let's say your year runs July to August, they use their 12 weeks of FMLA in September, October, and November, right? They would not qualify again potentially until your year resets. I'm not quite sure I understand if you're employed 30 days, you have to, that's okay. I understand what you're saying. So that goes back to whether the 1,250 is a barrier to entry, and I'll let Colin know that. And then for employees that don't usually work the summer, do we count the last 30 days they were scheduled to work? Or do we also count July, August? Oh, so that would be for support staff folks who are not actually working in the summer. And in that case, though, it's actually for at least, yeah, employed for at least 30 days. So if they worked for 30 days in June, then they didn't work in July and August, they would otherwise qualify. Right. So Teresa, I'll sort through that and send it to Colin. But I have been talking with people, and if they don't qualify because they otherwise haven't worked enough, they may not. So.
I want to thank Mike for taking his time today. I want to thank all of you folks for taking your time today. Please do email Lucy and I through the MeASBO website. I know I saw Lucy posted in the chat box. We do want to hear from you. We want to hear whether this worked or didn't work for you. Also want to hear about future topics. Like I said at the beginning, I will be sending out a letter and a survey within probably the next 2 to 3 weeks. I also need to get through the opening of school here at my district regarding a part-time position for MeASBO. That would be a paid position. And also about setting up a business meeting. That business meeting, most likely, I haven't talked with the executive committee, so they don't know any of this, but my goal would be probably mid to late October, so we can all get into the groove of the start of school. That obviously is going to be dependent upon if anything happens significantly with COVID between now and then. That meeting, as it would stand right now, would definitely be a remote meeting, but it would be a traditional business meeting instead of an educational forum like this. Hopefully you felt, other than the first 10 minutes of our presentation and question and answer, that this was worth your time. That's our goal. Our goal is not to overwhelm all of us who are already overwhelmed. It's to really consolidate down, get as much information out as quickly as we can in a 1.5 hour spurt, and not to create just another Zoom meeting, because I know we all feel zoomed out already. So hopefully that has provided some information for you. If you have other topics or questions related to this, again, send those through the MeASBO email. I will accumulate whatever questions come in over, let's say, the next week between now and next Friday related to what we talked about today. I'll get those off to Mike in one document so that he can answer them all, respond to them, and then we can send them out as one document. So why don't we give it 1 week from today for you to email questions in that you weren't able to ask today. And then we can kind of do a Q&A on those and email those out. Any last comments or topics that you need to discuss today before we let Mike and all of us go? Yes, Adam, on the recording, I just got to figure out, I'm not the technology guy, how to, my tech department, to retrieve this and get it in a format that I can get it to Lucy to get posted on the MeASBO website. That's my goal. Hopefully technology-wise that can all happen with whatever security measures we have here at 57 regarding Zoom recordings, and that I can make that happen.
Colin, also, at the beginning, you'd said something about the Social Security tax issue that you and Mike had talked about. Would you just reiterate that for everyone, please?
Yeah, that's not Mike's area in the Labor Department at Drummond. That's a Chris Stevenson topic. I see 2 or 3 people posting about that would be a good topic. We certainly can do that. I'll note that. But that really is getting Chris Stevenson involved in that part of it and talking about that. So thank you, Mike. I truly appreciate it.
You're all very welcome.
Attending. I hope you have a good rest of your day and a good week with the opening of school. We will probably gear a meeting towards the 3rd or 4th week of September. I'm going to take a couple weeks here to get the questions, get it grouped together, get the topics that you send, and everyone to start their school year, and then be able to do something hopefully third week of September in order to get the next topic and the next meeting set up. And that will certainly come out from Lucy through the ASBO email. Thank you all. Have a great day. Enjoy your weekend and stay safe.
Thanks, Colin.